Hey guys, welcome back to another episode of Business Law. Today we're going to be talking about Chapter 20 of the wonderful textbook. This is called Employment Law. So let's get right into it. The outline for this video is going to be introduction, employment at will, child labor, overtime, family and medical leave, other worker protections, privacy, and of course, as always,
key takeaways.
Awesome. Well, let's get into it. So the introduction is a little short because this chapter liked to dive right into the material as fast as it could. So the introduction is just simply this chapter and legal principles only deal with employees, not independent contractors. So keep that in mind as we go. We'll come back to it a little bit towards the end, but just we'll go ahead and keep that in mind. So let's jump into one of the fundamental doctrines of employment law, employment at will. So employment at will is a foundational legal doctrine at the core of employment law. This doctrine outlines that employees can quit anytime they want and that employees can fire people whenever they want. Make sense?
Mm-hmm.
Brother Hales stated that the at-will doctrine is central to the employment relationship in the United States. So, interesting. So, subsection of that, contract theory. Employers can create an express or implied contract for their employees. Many contracts of this sort are based upon people only being fireable for a good cause. So that's like the main point of contract. Now let's get into another subsection, tort theory. Funny word, right? Tort.
Yeah.
Basically means like wrongdoings or like illegalities. So, two examples of how torts can be involved at the at-will doctrine is from both employer and employee. So, an example, if an employee was fired via email to the whole company, and that email also disclosed private information to the public, a lawsuit could award that employee money for torts. Like that was wrongdoing, therefore they deserve compensation. Another example is fraud. If an employer hires someone for a job that will be gone in 2 months, like if they knew that job was disappearing, but they hired them anyway for that job after pulling them away from a company that was pretty successful already, that would be fraud. So that would fall under the tort theory.
If they disclose that when hiring, would that still be fraud? If they told them like this won't be a position at this time?
No, so I think it would. I mean, if you're upfront about it, I don't think it would be a tort. I think it would be.
But like secretly keeping that information.
Yeah, like if I told you I was going to hire you indefinitely, or that was the assumption that I would pay you $60,000 a year, but then fire you after 2 weeks or 2 months, that would be pretty tough, and it'd be illegal.
Okay.
So let's move on to public policy. So public policy is another very big aspect of the at-will doctrine. Laws being passed that prohibit firing someone based off of racial identity can lead to a large lawsuit. Make sense? According to Brother Hale's, successful lawsuits usually fall under this criteria for employment. Number 1, employees' refusal to commit illegal activities, accounting fraud, violation of antitrust laws, etc. 2, the employee attempting to exercise a legal right, filing workers' compensation claim. And 3, performing an important public obligation, jury duty, or whistleblowing. So if you're fired for some of those reasons, and you sued, statistically speaking, you'd have a good chance of winning that. So, at any rate, let's move on to the final little subsection of the at-will doctrine, wrongful discharge. Wrongful discharge is when an employee is unjustly fired. It can have a major lawsuit in some cases. Crazy, right? So, now onto the fun stuff. Child labor.
That was so fun.
Yeah. Fun to think about how terrible it was. The Fair Labor Standard Act prohibits children under 14 from doing most jobs. Agriculture jobs are fine, so you can work on a farm.
Like if it's your family farm?
Probably even if it's like your neighbor's farm.
Oh, okay.
Children 16 to 18 have limited hours that they can work, and but they cannot do hazardous jobs. But those restrictions go away once you turn 18. So, for example, when I was in high school, I couldn't work for more than like 15 hours a week, or 20 hours or something crazy like that. Yeah, it was a really low amount.
I worked 40-hour weeks or more.
Before 16 and 17?
Yep.
That's crazy.
No, not before 16.
I mean before 18?
Yeah.
Yeah, you are illegal.
I think
Just kidding, I don't know.
Does this apply to certain states, or is this on a federal level?
I believe it's a federal level. Yeah, this is a federal act. I don't know what exactly
Interesting.
you were doing.
Yeah.
I don't know. It could have been for any number of reasons, but let's figure that out in our own time.
Okay.
So, overtime. People who work over 40 hours are entitled to 1.5 times their pay. According to the FLSA, which is the Fair Labor Standard Act, which we just talked about. This does not include exempt workers that are executives, administrators, or professional workers. This is the reason why many companies like to hire independent contractors as well, because overtime laws do not apply to them. So make sure you get hired as an employee, and you want to be one of the elite employees. So, family and medical leave. The Family and Medical Leave Act allows employees to take time off work for family or medical reasons. Close quote. This time off is not paid and only applies to employers with over 50 employees, so like big company or medium to big companies. These laws state that an employee must be granted 12 weeks of unpaid leave for a year if any of the following criteria is met. Number 1, care for a newborn child within a year of birth. Number 2, to care for an adopted or foster child within 1 year of the time the child is placed with the employee, which is interesting, right? 3, to care for the employee's immediate family with serious health condition. Number 4, if the employee suffers from serious health condition and is unable to perform the essential functions of their job. Employers cannot fire anyone for any of these. They also cannot reduce their pay within a certain amount of time. If an employee is fired during or right after leave or returning from leave, they can sue for damages and even their job back. And in some cases, people have even sued for a promotion, which is very interesting. So let's talk about one of the, getting down to it, other work protections. So workers' compensation, when signed, prohibits the employee from suing the company. However, when injured on the job, they are entitled to compensation. So it's kind of like a little contract again. This does not apply if they injure themselves being reckless outside of work. Unemployment insurance. So when fired for any reason, excluding like crazy things like theft or failure going to work, like you just stop showing up, someone can apply for state benefits. Social Security disability. For that, a person must have become disabled and prevented from doing any full-time work. That includes like any job. So I think an example in the textbook was if you were like some manager somewhere and you became disabled, but you're still able to fold towels for 40 hours a week, you're going to be folding towels. You're not going to get a Social Security check, which is kind of interesting, right? And let's talk about the Affordable Health Care Act, which is also known as Obamacare. This requires medium and small companies to include insurance for their employees. It's great. Privacy. Employees have the right to privacy. Work calls and other forms of communication can be monitored by the employer, but they cannot monitor private calls and private emails. So if they did that, they would have issues on their hands.
Okay.
So let's go ahead and talk about key takeaways. So this chapter was very informative. it was insightful to know, as you know, I myself am an employee. She's an employee.
We're all employees.
Pretty much everyone's an employee somehow.
Mm-hmm.
And so this is very connective. I thought that this related very well to just a lot of life experience. I really liked the insights that Brother Hales shared about how the at-will doctrine is like a key fundamental part of the employment law. Without it, there isn't too much. So, well, thank you guys for watching. This has been super insightful reading. I hope you guys were able to understand this chapter as well as us. If you have any questions, as always, feel free to leave them in the comments. Don't forget to like and subscribe, and we will see you guys next week.